Just did a video response to this same user who commented about banks not wanting to accept a large 32-page power of attorney. So check out my video on that. But I wanted to address their second issue here. It says, good luck getting a bank to accept one with a springing provision. So what is a springing provision? Well, let me tell you. Springing provisions in power of attorneys say that the document is not effective. Otherwise, the agent has no authority until and unless one or two doctors, depending on how you wrote the document, but one or two doctors deems you, the principal, incapacitated to make your own decisions. However, the springing provision has been disallowed in Florida since October of 2011 when the power of attorney statute was amended here in Florida. And in October of 2011, it says any powers of attorney that were drafted after this date shall not be springing. And if they are springing, they are void. So the first thing is many attorneys suck and use old forms and they just copy and paste names in there. And for up to a decade or even longer at this point, after the law has changed, they're still spitting out springing powers of attorney and charging clients for it. Clearly malpractice. They're terrible lawyers. You shouldn't use them. But when it comes to the bank not accepting it, it all depends on when the document was executed. If it was after October 31st of 2011, then I would agree that the bank should not approve it or should not accept it because it is void, because it doesn't follow the statutory requirements. However, documents before October of 2011 are grandfathered in even with the springing provision. So again, I would advocate on behalf of my client who may be currently incapacitated and therefore can't sign a new one, which I would always prefer them to do. But if they're stuck with what they have, then I would call up the bank. I would speak to their legal department. And I would let them know that here is a copy of the Florida statute. Here is the change. This document has a springing provision, but it was executed prior to the law changing. So it is grandfathered in. It is enforceable. And if you don't accept it, we will sue your ass and we will get attorney's fees for a judge to force you to accept it. So ball's in your court. How do you want to handle it? You need a good lawyer that will advocate for you. Have a great day.